there been a day that's gone by?
Lawyer.
It's completely changed. We have a small family to begin with, and it's taken away I won't say it's taken away happiness, and I've done a lot with therapy and grief, and it's never gonna go away. But there's never going to be pure joy in the celebrations that we have, because there's always going to be one of the big pieces of our joy missing. So
And with respect to the family, your sister, Brownie, people we have heard from, have you seen how this has affected them?
oh, it's everything. It's how we operate in life now. It's even how I allow my son to do things, because we are a normal family. This isn't anything you ever think you're gonna talk about. When I say we were boring people, and we liked it that way, and just, you can't let go of the fact that this type of thing now, really happens to other people. It happens to you too, and it can happen to you. And so it impacts every decision, every thought. There's just, across the board, with my sister, with, our father, with my husband, my son was 10 at the time, and just trying to explain to him why somebody that was, just like a sibling to him is no longer here.
I was gonna ask about that, because Jade and your son would be cousins,
They were cousins, but they were,
closer than that.
they fought like brothers and sisters, and she was 13 when he was born, and then she turned into his babysitter, and then, she hit adulthood, and he had a little bit of a problem with her being an adult and not just his cousin Jade. So they fought like brothers and sisters, and there's just, it's really hard for me, like I said, because we have a small family, and my husband and I had our son late in life, and we don't have a lot of other relatives, and she was his only cousin, and he's not gonna have her now later in life the way I've had my sister. Like, I relied on, and she watched out for him, she could put him in his place like no other, and just, it kills me that I know that he's not gonna have that anymore.
And have you seen that actually affect your son?
Oh, definitely. Our entire family has gone through therapy. He had a lot of problems right when everything happened in school, just with behaviors. And it's impacted every single day since it happened.
Prior to this, was your sister family unit happy?
Oh, yeah, definitely. We were, my husband and her husband are good friends. She and I are best friends, and like his children, like we all were just beyond just a happy, like I said, happy but boring, normal family. And there's just, I think somebody mentioned Jade's light, and that light's gone, and there's a dimness over our entire family that I don't ever see us getting back.
Can you describe, put in words, what you have seen this do to your sister, to Jade's mother, Ivy's grandmother?
It's just destroyed her. When she talked about Jade being her life, she was her life. They talked every day. And aside from the fear and the hurt I know she has, I've lived with the fear of like, is she going to be able to get back at us? And thinking about my sister not being here because she can't live without her daughter has been probably one of the hardest things that I've sat and just prayed and hoped that she is strong enough and will be strong enough, because I can't imagine. I look at my own child every Mother's Day and feel guilty that he's still here, and my sister doesn't have her little girl anymore.
Brown. No further questions.
Hang on just a moment. Question from the.
No question.
All right, thank you. You can have a seat. Who's the next witness?
Ms. Browning.
Do you swear the testimony you're about to give to be the truth, so help you God? Yes, I do.
Ms. Browning, could you please state and spell your name for the record?
Yes, it's Andrea Browning, Anderea, Browning.
Ms. Browning, what was your relationship to Jade?
She was my bonus daughter.
When did you and Jade's dad get married?
2009.
When did you first meet Jade?
She was about 7 years old, which is how old my daughter is now, our other daughter, Ava.
And can you walk us through Jade's early life?
Yeah, she was a little spitfire. The first time I met her, I'll never forget, because the light everybody keeps talking about, it's so obvious. And I was just, this girl was so full of life and so full of confidence. She always had a smile on her face, and she was always ready for anything. And she adored her dad and her family. She just, you could see it all over her face and her body, her whole body lit up.
And Ms. Browning, do you have another daughter?
Yeah, Ava.
How old is Ava?
Ava's 7 now. She was 3 at the time.
And can you describe Ava and Jade's relationship?
Yeah, that's tough because, like I said, Ava has Down syndrome, and so she's developmentally delayed, and she didn't know Jade because Jade was in Arkansas when Ava was born, and it was also during COVID, and we were taking lots of precautions about who we were exposing her to. And she finally met Jade in, I believe it was 2021, and they looked into each other's eyes and knew that they were sisters. You could connection immediately. Like, it was really eerie, but also amazing at the same time. But having her here was so great for Ava because she got to know her last year. And also the toughest part about it was that that's it. That's all Ava gets of her, was just that 1 year when she was 3 years old.
And what impact have you seen on Ava's life since losing Jade?
It's tough to tell her because she doesn't understand a whole lot about it, especially because she was so young at the time. But she's really into pictures, and she's always wanting Sissy out in pictures. And she asks about Sissy. She uses a KAC for communication. She just randomly hits Sissy on her words all the time. And it's got a little picture of Jade. And Sissy's always with you, so we can tell her and just keep explaining to her how great and wonderful her sister and how much she loved her. And, one of the toughest things I'll have to carry with that is that the Instagram post that Jade made that said, being in Nashville, one of the best things about being in Nashville is getting to watch my sister grow. And they will know her.
And can you tell us about finding out Jade was pregnant and how excited the family was?
I was so excited. I was initially shocked, and she could see that, and I think it was a short conversation, but we were automatically super supportive of her and super ready to do anything and everything, take her shopping, help her with decorating, help her with anything she needed help with. I mean, I had just become a mom myself not that long ago. We talked a lot just about, whatever you need, we've got you. And she didn't ask for much. She had a whole bunch. She knew she could do it. She's got all the confidence in the world.
And the jury has heard a lot about Jade's support system and how many people showed up to Vanderbilt and how many people took action that night. Can you describe for the jury Jade's support system, how many people she has here today, and what it's done to her friends?
I can't even begin to describe it because, like I said, she had only been here a year and she was surrounded by people that were local, like at the end. I mean, obviously everyone from Arkansas came down, but the amount of people that came there that were not from Arkansas, that were there because she made an immediate impact on them. And they loved her so much and they knew that this was going to be a huge loss to everybody.
And can you walk us through that night of February 25th and how you found out and how Jade's dad found out?
Yeah, I was actually asleep. I had a young child at the time. I had put her down a couple hours before and I knew she was going to be up early, so I was sound asleep. And once I woke up, I saw the missed calls. And I was in such shock. I honestly don't remember a lot of like who called when, where, how. And I know Bridget had several missed calls from her as well as Dennis. And as soon as I talked to Dennis and got to Vanderbilt somehow on my own, that drive was awful. I could barely even operate my legs because I knew there shouldn't be anything wrong with her.
And Jade was working at your brother's restaurant back in early 2023.
Right.
Can you describe the impact that her and Ivy's death has had on your brother's staff, your brother, just the restaurant as a whole?
Yeah, it was devastating. It's been really hard to watch my brother because he hired her. I mean, he didn't even hire her. He recommended her to the head chef, and it was a no-brainer for her to hire Jade. You know, he just got her the interview, like, but everyone at that restaurant, like, and that's the biggest thing is like, they knew Jade was not doing anything she shouldn't be doing. And they were like, always telling me that.
Yeah,
How great she was taking care of
Maybe
all
a Julia
the things.
correction, I'm sorry.
Okay. All right, what's your next question?
It greatly devastated him. I can just leave it at
And Ms. Browning, is Jade's dad Dennis Browning?
that. Yes.
And can you walk us through the impact that Jade and Ivy's death has had on you and Dennis?
It's just been devastating, just knowing that Jade is only sister, and we know that she was always going to be around for her when we weren't, and it's ripped us apart, it's brought us closer together, but it's changed everything. We are very much more protective of Baby now, having experienced what we experienced, and I know that it's just changed everything forever for us.
Those are all my questions.
Any questions?
No question.
Thank you. All right, who's the next witness?
Ms. Bridget Burks.
You swear the testimony you're about to give to be the truth, so help you God.
Could you please state and spell your name for the record?
Jade Benning Burks, BRIDGET, BENNING, BURKS.
Ms. Burks, who was Jade Benning to you?
My baby girl.
And was Jade your only child?
Yes.
How can you describe Jade growing up and her light?
As soon as she walked in the room, you knew, because she was so full of life. She's known for being very loud. Got in trouble several times for being loud. So you knew her presence, her laugh.
And Ms. Burks, does Jade have a stepfather?
She does.
Okay, what's his name?
When it works.
And when did Lynn Burks come into Jade's life?
She was 6.
And can you walk us through the impact that Jade's passing and Ivy's passing has had on you and Lynn?
We also have 2 boys. I'm sorry, it just makes it harder, makes us worry more about our other 2 boys. That was his baby girl. You couldn't tell him any different. And it's just a boy that will always be there.
Is your day-to-day life different without Jade?
Most of the time. People ask, are you okay? And I always say yes. But behind closed doors, I'm not.
And did you and Jade talk almost, if not every single day?
Yes.
And Ivy would have been your first grandchild?
Yeah.
Can you walk us through the impact of losing Ivy?
Well, I'm the youngest of all my friends, and I'm the only one that didn't have a grandchild. So I was excited to be able to say I'm a grandma now. I'll never get that opportunity because it was taken from me.
And is there a day that goes by that you don't think about Jade and Ivy?
No, every day.
These are all my questions.
Any questions?
No question.
Thank you. Have a seat. Any other witnesses from the state?
No, Your Honor.
Any proof on behalf of Mr. Taylor?
Yes, Your Honor. Very, very briefly, I would actually call Detective Adam Reese, who I believe is in the court.
Okay.
You started the testimony about to give to the truth, so yeah.
Detective Reese, as part of your investigation in this case, did you pull criminal history reports on Mr. Blaise Taylor?
Yes,
Do those include NCIC sort of nationwide background checks?
yes,
In your investigation of criminal history on Mr. Taylor, did you find any prior criminal history?
no, I don't.
Thank you, that's
Any questions?
No.
Okay. All right, who's the next witness?
Your Honor, we would call Evie Taylor.
Okay.
Do you swear that the testimony about to give to be the truth, so help you God?
It's Dr. Taylor, right?
Yes,
Dr. Taylor, can you please state your full name and spell it for me?
it's Evelyn Taylor, Evelyn Taylor.
And Dr. Taylor, what is your relationship to Blaise Taylor?
He's my son,
And how many children do you have, Dr. Taylor?
too.
And is Blaise your older child or younger child?
He's my oldest.
And how old are your two children?
30 and 28.
So Mr. Taylor is how old?
He's 30.
Where do you live, Dr. Taylor?
I live in Texas.
Can you tell us a little bit about who Blaise Taylor is?
Yes. He's the best son I could ever ask for. He's a loving son, a loving brother, a loving grandson, a loving nephew, a loving friend. He's never given me any problems. All throughout school, he was an A student. He was always the teacher's pet. In fact, his kindergarten teacher still keeps up with them to this day. He liked to help other children with their schoolwork because it just naturally came so quick to him. And the teachers would always comment about that. He loves sports. He wanted to follow in his father's footsteps, and so he played sports. Every time we moved, he made a lot of friends. He was team captain and leadership. He was a team leader. A lot of the parents would come to me and tell me that how much respect they had for him. He was a good student in the classroom and in sports, and he was the type of boy that they wanted their children to hang around because he was never getting in any kind of trouble and was very respectful.
Where did I'm gonna interject for a minute. Where did Mr. Taylor grow up?
We lived all over. He was born in Texas, but because of my husband's profession, we move every few years. So we lived in Texas. From there, we went to New Mexico, and then Louisiana, and then Tennessee, then Oklahoma, and then Alabama, and then Arkansas.
And is it fair to say sports are kind of a big deal for your family?
Yes.
So you mentioned he was very involved in sports. What sports specifically was Mr. Taylor involved in?
Well, his favorite sport was football.
And that's real big in your family.
Yes.
When did he start playing football?
When he was 5 years old.
And how long did he play?
He played through college, and then he got an invite to try out for the New Orleans Saints upon graduation or after his senior year.
And he ended up not pursuing it professionally?
He didn't make the team, the Saints.
Let's start with high school. How did he perform in football in high school?
He was a team captain in high school, one of the leaders on the team. He actually graduated early. He graduated a semester early, so he could go to college early.
And you mentioned a little bit about his grades while he was team captain and playing football. How were his grades in high school?
All A's.
And then where did he end up going to college?
He went to Arkansas State University.
And I think we heard a little bit about that during the trial. Did he play football in college also?
Yes, he played football in college, and he actually graduated with his bachelor's and his master's degree in business in 2.5 years. He was the first college football player to ever do that. And while he was there, he started a nonprofit, Power 102. He's very passionate about helping children in underserved areas and communities. And so while in college, he and his sister co-founded that nonprofit. And they just did a lot of community events for those children, mentored them. He was a big brother. He volunteered at the alternative school. And his senior year, I think he went like 3 times a week.
Does that nonprofit still exist?
The nonprofit still exists. They've actually given almost like over $90,000 in scholarships. They help, each year they do school supply drives for kids in underserved areas. They do Thanksgiving baskets and adopt a kid for Christmas for children that don't have resources to get presents for Christmas. Pretty much whatever the needs are wherever we live in the community, they just try to serve those children and just meet their needs.
And you said Mr. Taylor's sister was involved in that as well?
Yes, so if you talk to his sister Star, she'll say that he's her role model. She followed behind in his footsteps, and she's an A student as well. And if you ask her why does she make A's, she'll say because Blaise did. Why do you play basketball? Because Blaise did. From the time she was little, he would help her put her shoes on the right feet. When I was her coach, she would be looking at him. And even though he was only in junior high, she valued his opinion and wanted to hear what he was saying, what she can do better, how she can improve. Whether it was in the classroom, whether it was with sports, whether it was trivia things or whatever, whenever she needed advice, she would say that she would go to her brother.
And is Blaise's sister here? Has she been here?
She is. She has been.
Is your family close?
We're a very close-knit family. When we move a lot, we know we have each other, and then every time we move, we make several moves that we always find like adopted families wherever we are. Usually it's through sports. The kids on their sports teams, and then they become a part of our family.
I know that this process has been very hard. Does Mr. Taylor have support still from your family?
Oh, yes, he has support from our family. We have family members here. It's just hard because we're not from Tennessee. And we've had lots of different moves of people that we're close to are in various states across the US.
So when Mr. Taylor started working for the Titans, which we heard a bit about, he was in Tennessee and you were still in Texas?
No, we were in North Carolina at that time.
You were in North Carolina. Okay. Did you have an opportunity, did you keep up with sort of how he was doing at work?
In work, yes. We talk regularly, and football's a big part of our family. That's what his dad does, so we have lots of conversations about work.
What's your impression of Blaise's work ethic?
He has a really good work ethic. If you ask anybody that knows him, that's one of the characteristics they'll say. He's a hard worker. He's always on time. He'll be one of the first ones there. He's going to make sure that he gets the job done. He has a really good work ethic in everything he does, whether it was his schoolwork, an actual job where he's getting paid, whether it's a non-service, he always goes above and beyond.
Okay. How about, are there any other, we talked a little bit about the nonprofit, are there any other kinds of community involvement or examples that you can think about from Blaise's life, either recently or longer ago, that you can tell the jury about?
Well, he has a servant's heart, so he does a lot of community service. Usually wherever we live, like with his dad, the football teams usually do community service, so he'll be involved in various things they do. I know one thing, like when he was in high school, where he was actually old enough to make a decision to do those things, he was really involved with the Miracle League. And so that's something he did throughout high school, with big brother type programs, mentoring younger children, he would do that. And then when he was in college, he just did a lot of community service, like I was telling you about, like for his nonprofit. But it was primarily through being a big brother and volunteering at the alternative school. So being a mentor, he had a little brother that was assigned to him. And he would bring him to football practice and let him watch. He would go to school and help him with his homework and do things of that nature. And then when he volunteered, I believe it was the 3rd grade classroom at the alternative school, he would just encourage them to do their schoolwork, to respect their teacher, and if they made their points for the week, he would come and he'd bring teammates, and then they would play dodgeball and things like that. And if they had a good week and a good report, he would let them come with him to, or he'd get tickets for them to come to the football game. And he was really involved with the community baskets, and we would do community Thanksgiving dinners. I think one of the things that I'm most proud of Blaise for was one time when he was in college, we were in church, and they were doing baptisms. And I didn't know this because, he didn't tell me this. I'm just watching the baptism, and all people come up and give testimonies, and it was a young college girl. And she said, I just want to thank Blaise because he really shared about the Lord to me. And he's really instrumental in my relationship with the Lord and my baptism. And all the accolades that he had, like in the classroom or on the field, they were nothing compared to what I feel like he did for this young lady that said that she's a friend that just went to the university. And just the fact that he was instrumental in her being baptized, is those types of things that make me really proud of Blaise.
Dr. Taylor, one second. Thank you, Dr. Taylor. I think that's all. Well, let me ask this. Is there anything else you think you want to share with the jury that I haven't asked you about?
Your Honor, I would object to being that open-ended.
Okay.
And that's all I have.
All right. Any questions from the state?
No, Your Honor.
Thank you.
That is the defense's proof there.
Okay. All right. Ladies and gentlemen of the jury, if you'll step down the hallway just briefly, we'll talk with the attorneys about legal issues and then get you right back. You can have a seat. And just for the record, Mr. Bland, like we did the other phase of the trial, let Mr. Taylor step around and deal with his decision not to testify. If you raise your right hand and be sworn.
Do you swear to tell the truth, so help you God?
I do.
Mr. Taylor, you understand that the sentencing phase of the trial, you have an absolute right to make a statement to the jury.
I do.
You also don't have to say anything, you have the absolute right to remain silent.
I do.
And we have discussed that option and the pros and cons, and whether you want to make a statement at this point in time.
Yes.
And based on those discussions, you made the decision that you're not going to make a statement or otherwise testify.
Yes.
And that's your own decision.
Yes. All right, he can have a seat. And then, Mr. Brand, in terms of the mitigating circumstances that I'd instruct the jury would be the defendant has no significant history of prior criminal activity. Set out the other mitigating factor raised by the evidence consisting of, and what do you contemplate the court instructing the jury there?
Trying to think of how to phrase this, Your Honor.
Right. I mean, excellent student.
I might. What if we said, community involvement, prior acts of service, support system, and educational and personal achievements? That maybe in the ballpark?
or community involvement, education, and personal achievement, and what was the other?
Acts of service.
Active service?
Acts of service.
Acts. Does the state care to be heard on that?
No, Your Honor, I think they come under the catch-all.
Okay, and I was planning on setting forth that catch-all about any other mitigating, but then consisting of and then listing.
Yes, Your Honor, I think that would be appropriate under the case law.
And then charge as to in terms of aggravating circumstances in counts 2, the murder was committed against a person less than 12 and the defendant was 18 years of age or older, and the murder was knowingly committed, solicited during the commission of the language there about another first-degree murder.
Yes, sir.
Accurate. And in 3, it would just be that felony murder type language.
Yes, sir.
And 4 would be both again.
Yes, sir.
Well, both
Yes,
again. Or anything further from the state in terms of jury instruction?
Not without having seen that.
Do you want 10 minutes before we come back with the closing argument? And I can give you the draft.
Just want to make sure that I don't say anything that's not going to be on in the charge.
Yeah,
Okay.
I would appreciate seeing the jury instructions, but we don't need much time.
Okay. All right. Give the court just 6 minutes.
Causing a brief mistake.
In the jury instruction.
No, Your Honor.
Mr. Brown, okay. All right, let the jury step down. All right, you may have a seat. All right, any closing argument on behalf of the state?
Yes, Your Honor, thank you. Members of the jury, we're down to just about the last decision you have to make. And that is, what is the appropriate punishment in this case? I'm going to start out by saying that, yes, the judge will tell you that a life sentence in the state of Tennessee today is 51 years before parole eligibility. That's a long time. It's a really long time. But contrary to what Mr. Brand said about life without parole being the harshest penalty, the harshest penalty wasn't asked for, the death penalty. So there are 3 punishments for first-degree murder in the state of Tennessee. 1 wasn't on the table. Life without parole is the next step down, and life imprisonment is the minimum sentence for first-degree murder. The state submits that while there might not be a quantitative difference, who knows how long someone is going to live, but there is a qualitative difference. That is, what does the crimes that you have found Mr. Taylor guilty of, what do they deserve? And you can consider, submit by your verdict, we already mentioned this, you found the aggravating circumstances by your verdict beyond a reasonable doubt. That then allows you, and Judge Dozier will read the instructions, not nearly as long as the first one, that upon that finding, you can consider victim impact testimony. What this man's actions have done to the people who love Jade Benning and would have loved Ivy and did while she was in the womb. She never got a chance. She never got a chance to know how much she was loved. Mr. Taylor, the judge will tell you, consider mitigating. Yeah. Before this, he had no criminal record. That doesn't mean he is not deserving of life without parole under the facts of this case. And again, going back to everything that you heard during the trial, Apple Denny. Apparently, Mr. Taylor was fine with helping out other people's children. He was a good student. No doubt about that. very smart man, comes from a very well-educated family. A good athlete. Community service. And like I said, good to other people's children. That qualitative difference is that life without parole, the state submits to you, is the appropriate punishment. And you'll really have to decide that and come to on each count. But it is your decision, your collective judgment. There's no, oh, we have to prove this, we have to prove that. Once the existence of an aggravating circumstance is before you, and here we have to, then it is your call. And one of the things, victim impact, and you've got, certainly, his parents didn't raise him to be like this. But the decisions that he has made were his alone. His family choose to do so. Visit him. So long as he's alive, talk, communicate, whatever. Because there's a saying, where there's life, there's hope. He's going to be alive. He's going to have hope. He's going to have that sense of living and associating and being, granted, not an environment that any of us would want, but it's of his own choosing, his own making. Jade and Ivy's family never have that opportunity. He took that from them 3.5 years ago. February 25th, 2023. He took something that no one is able to give back. And for that, on behalf of the state of Tennessee, submit that whatever hope of freedom that he should have, he does not deserve, and that he should not receive the minimum punishment for these offenses. Thank you very much.
Any argument on behalf of Mr. Taylor?
Thank you.
Life imprisonment is an appropriate punishment for Mr. Taylor. And punishment is what it is. It is not a minimum get off easy kind of sentence. It is life in prison, 51 calendar years at best. That's if you make parole at 80, if he's 30 right now. Yes, in opening I said it's the harshest you have is life without the possibility of parole, and there is death penalty, but this isn't a death penalty case. We knew that at the beginning. It's the harshest option you are considering today. And life imprisonment is incredibly harsh. Living in a concrete box for the next 51 years, that is punishment. He's not getting off. He's not getting off easy. You're not letting him go. He's not walking out of this courtroom. Likely for the rest of his life. Now, looking at the jury verdict, it occurs to me that maybe there is some consideration from the jury that you all think Mr. Taylor intended to kill baby Ivy and maybe didn't have the intent to kill Jade, but he knew he was killing her, or some version of that. Obviously, I'm not in the jury room. I don't know if that matters in your deliberation for this part of it, but if we're talking about what are the worst of the worst of the worst crimes that you get the worst of the worst of the worst punishments, this was a long, incredibly detailed, complicated trial. And you guys heard a lot. You can consider all that when you're making your determinations. The reason that we put on some proof about who is Blaise, what was his family like, what's his upbringing like, what's his community involvement like, is there's kind of a, I don't know if it's a saying, it's something that's talked about in work when you defend someone sitting at that table, that we are more than the worst thing we've ever done. We're people. Blaise is a person. He's got a family. He had a great childhood. He did well in school. He was an all-star athlete. Yeah, he did something horrific. Nothing that can happen here is ever going to change that. Nothing. And he's going to spend the rest of his life in prison no matter what. So you all can go home and rest assured that no matter what you do here today, he's going to spend the rest of his life in prison. It doesn't require life without the possibility of parole to send that message, to send that punishment. It's not either we let him off easy or we have to punish him the worst of the worst of the worst of the worst. He's being punished. He's getting the message. But he is not someone who has spent his entire life as a criminal. He is someone who's had a good life, who's done good things. I don't have anything to say about it. Did something terrible. There's, let's call it what it is. When you hear the jury instructions, there's going to be a lot of talk about aggravating and mitigating factors. And I said this in my opening, and I'll say it again. If you find aggravating factors, you don't have to find that he gets life without the possibility of parole. It's just something you can consider. Life imprisonment is punishment. It's life in a box. It's life in a prison. It is a message. It is a lot. It is enough. And we would ask you to return for your sentencing that be the appropriate sentence in this case.
All right, any rebuttal from this?
Just very, very briefly, it's time to have this jury determine, does he deserve the minimum allowable? Or does this crime, these crimes, Mr. Brand argues this is not the worst of the worst. What could be worse than killing your own child and your own child's mother? That is my life without parole is an option in this case, and is an option the state of Tennessee would respectfully request you consider and return. Thank you. Thank you, Your Honor.
All right. Members of the jury have now found the defendant Blaise Taylor guilty beyond a reasonable doubt of murder in the first degree as charged in counts 2, 3, and 4 of the indictment number 2024-A49. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for this offense. Tennessee law provides that a person convicted of a murder in the first degree shall be punished by imprisonment for life without possibility of parole or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravated circumstances proved beyond a reasonable doubt and any mitigating circumstances which may have been raised by the evidence throughout the entire course of this trial, including the guilt finding phase or sentencing phase or both. The jury is the sole judge of the facts and of the law as it applies to the facts in this case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required, and this certainty is required as to every element. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given the evidence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, or physical effects of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravated circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance which has been alleged. You may consider this victim impact evidence in determining the appropriateness of the sentence only if you first find the existence of one or more aggravated circumstances as has been proven beyond a reasonable doubt by evidence independent from the victim impact evidence. Count 2, statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. And 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempting to commit any first-degree murder. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Members of the jury, the court has read to you the aggravated circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstance in deciding whether imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. The defendant has no significant history of prior criminal activity, and 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character, any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. Count 3, the felony murder involving Jade Benning, statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or is fleeing after having a substantial role in committing or attempting to commit any first-degree murder. The definitions of knowingly, intentionally, which apply to this offense, have been previously explained to you in these instructions, and you should refer to those definitions as they apply to this offense. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravated circumstance in deciding whether imprisonment for life without possibility of parole would be an appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, the defendant has no significant history of prior criminal activity, and 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspects of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. Count 4, felony murder involving the victim, the unborn female child of Jade Benning, statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more statutory aggravating circumstances, which shall be limited to the following. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempting to commit any first-degree murder. Definitions of knowingly and intentionally, which apply to this offense, have been previously explained to you in these instructions, and you should refer to those definitions as they apply to this offense. Members of the jury, the court has read to you aggravated circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravated circumstance in deciding whether the imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, the defendant has no significant history of prior criminal activity. 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. The defendant has not taken the stand to testify as a witness during the sentencing hearing, but you should place no significance on this fact. The burden is on the state to prove any aggravated circumstance or circumstances beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. You will be provided a verdict form consisting of 6 pages. You have 2 sentencing options to consider on each count, and you are not required to deliberate on these sentencing options in any particular order. The options are as follows. Verdict, life imprisonment or life imprisonment without possibility of parole. If you do not unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravated circumstance or circumstances have been proved by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory circumstances or circumstances proven by the state beyond a reasonable doubt, and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravated circumstance or circumstances so found, and shall return your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravated circumstance or circumstances beyond a reasonable doubt. Here on the verdict form, you would list the statutory aggravated circumstance or circumstances found. You shall then indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. You will be provided with a form for all possible sentences in this case. The jury will check the appropriate verdict on the form for each count and complete the form as directed, and each juror will sign the verdict form. The other forms are to be left incomplete and unsigned. Your foreperson will preside over your deliberations, and when you have reached a verdict as to the sentence, you will return to the courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them, and have attempted to read this charge to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the charge in this case is herewith handed to you, together with the verdict forms for the punishment for each count and the exhibits. You may now retire and consider your verdict. You can step down the hallway with the court. Anything further from the state?
There's another, need to be a hearing, sentencing hearing. I don't know if we had a date, we might also be, will be in our
Yeah, in
calendars.
terms of merger and count one,
And,
whatever happened.
yeah, sure, and,
And we can look at like the week of the August 3rd, like the 5th maybe, or somewhere around there. Discuss that.
yes, that's all.
Anything further on the jury charge, Mr. Brown?
No, no.
All right, we'll need a recess.
Court to the recess.
Oh, yes, there's a merge with it, yeah. And, police officers, even when it's secondary merges, that the court shouldn't impose a fixed sentence. So we don't have to, if for some reason.
I'm gonna ask to go further on August 5th. I can't imagine.
There's, yes, pretty much more.
I'm gonna say like, maybe, is that crazy? We need to rush this, is that like?
Yeah, we just. Yeah. What, yeah. That's why I was asking, did you get a confirmed date, so.
That's what I mean, we're not gonna rush, right? We don't do it.
If we could do it in August, I think that would be our preference.
Hey, almost 50, if he gets a little bit of those, they need like 50 days or more, they're like stacked.
That's kind of what we're thinking that for.
Yeah, it's like, it's like, man, they just asked for 45 days, like, a week ago, so now they need like 30 days. Yeah. But I was like, there's that non-jury before you know the seventh and the 11th. So that might be an option. I mean, you know, big.
That would be better.
Yes.
Okay.
Right. Yes. We all want to know. Please don't. Right.
worse, and they're worse.
Right. They'll be fine tomorrow. I know I was ready to jump out. That was definitely silly. What? Yes. Right. I know, I'm sweating.
So, because I can be murdered.
Yes.
Yeah, just a little bit, but I'm sorry I figured it out.
They are.
Well, did somebody say something? Sorry. At this point, we want to make it, yeah.
I know.
That's what I'm saying. Yeah. Yeah, there's.
Yeah. He likes.
Oh, yeah.
I mean. Yeah.
Phalanx is lined up outside.
I want to see that happen. Get away. Oh, I know. It's just been wacky. I was just counting Sunday. It's
Well, yeah.
just been draggy.
Yeah, I literally lost count.
Yeah, probably not.
Well, that's.
Yeah.
Yeah.
Yeah, you told me about that. What was the other one? Yeah. Yes, yes. Yeah. Should have gone back to the office. Did you go to sleep?
Yeah, I was gonna say. Did you get?
Three.
3:30.
I was up at 4 too. So I was up at 4 too, and I thought that was. Yeah. It's like 5 hours. Oh my gosh. Yesterday. Yesterday. I should rely on my notes. And I was like, oh wow. That's what I was getting. Yeah. It worked.
I don't know. Yeah. I mean, she is. Yeah. Right, because it definitely would not have been. No.
It is very sad. She's been gone for 6 weeks.
And just. Native water. Good. No, we did. Now, Raven and Andre Johnson. Well, one thing too, though.
Hopefully it's not.
Murder and potential felony warrant or Sarah. That's why it's been 6. Yes, it's
Taylor's. All right, the court staff's been made aware the jury's arrived at a decision in terms of the punishment phase, so we'll let them step down and announce it. And was there an agreed on date on any sentencing issues?
I think the clerk is looking at possibly a date in September.
You want to do the 9th? Check that, let us know if it's not. All right, all right, juror number 7, you are still the foreperson, and the jury's arrived at a verdict in terms of the sentencing issue. All right, if you would, please, ma'am, stand and announce that verdict from the jury verdict form.
We, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. 1, the murder was committed against a person less than 12 years of age and defendant was 18 or older. 2, the murder was knowingly committed, solicited, directed, or aided by defendant, while defendant had a substantial role in committing first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life.
And that is
Count 2.
Okay,
For count 3, we, the jury, unanimously find the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. 1, the murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing or attempting any first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. And for count 4, we, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 or older. 2, the murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing any first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life.
all right, and that's signed by each of the jurors.
Correct.
All right, you can turn that document into the court staff. Anything further from the state?
No,
Anything further on behalf of Mr. Taylor?
no, Your Honor.
All right, ladies and gentlemen of the jury, I appreciate very much your service for the last week plus to the court and your community. You'll be discharged from this case and from your jury service. You can step down the hallway with the court officer. All right, Mr. Taylor, you can have a seat. Mr. Taylor, you've heard the verdict in terms of the punishment. Counts 2, 3, and 4 that the jury is imposing a life sentence in each of those counts. That verdict will become the judgment of the court. We'll set this on 9/9 for any sentencing issues, merger issues. And if that date doesn't work, Mr. Brand, just let us know in advance.
Yes, they do.
All right, let Mr. Taylor step in the back. All right, we'll be adjourned.